Utah's death penalty is reserved for only the most serious of crimes, and this was truly one of them. After threatening to kill Claudia Ben, Taberon Dave Honie arrived at her home uninvited. He smashed his way into her home through a glass door and severely beat her, bit her, slashed her throat 4 times, stabbed her in the vagina 3 times, stabbed her in and around her face, and was about to her but stopped when he realized she was already dead. Claudia's 3 young granddaughters, ranging from 22 months to 4 years old, including Honie's own daughter, were in the house when Honie committed these atrocities. And at least one of the granddaughters most likely witnessed them. While hiding from police in the home, Honie put his finger in the vagina of Claudia's 4-year-old granddaughter, rubbing hard enough that she bled there for hours afterward.
Welcome back. We have breaking news this afternoon. The Utah Board of Pardons and Parole has granted death row inmate Taberon Honie a commutation hearing. Now, Honie was sentenced to death in 1999 for the murder of his ex-girlfriend's mother. Now the board is giving him one last chance to spend life in prison. That hearing will happen sometime in July. The last commutation hearing in Utah happened back in 2010 in the case of Ronnie Lee Gardner. He was later executed. Honie is scheduled for execution on August 8th.
Today, we're going to be watching the clemency request for Mr. Honie, a death row inmate in Utah scheduled for execution Tuesday, August 8th, 2024. Now, this case presents a complex set of issues that challenge our understanding of justice, mercy, and the power dynamics within our legal system. On one side, we have arguments for clemency. Supporters of this request believe that Mr. Honie's case deserves reconsideration, potentially due to factors such as remorse, rehabilitation, or mitigating circumstances that may not have been fully considered during his trial. On the other side, we have those who believe that the original sentence should stand. They argue that the decision was reached through due process and that the severity of the crime warrants the punishment as determined by the courts. One of the intriguing aspects of this case is the role of the Clemency Board. This body, which ranks lower than the judicial hierarchy, lower than the Supreme Court that upheld Mr. Honie's death sentence, this board is not an elected judiciary, can actually grant clemency, can overturn the Supreme Court's rulings. This raises question about the balance of powers within our justice system and the purpose of clemency in our legal framework. As we watch this case, I invite you to consider these competing viewpoints, examine the facts, and consider the broader implications of clemency decisions in our justice system. And with that, let's jump in.
Honie has continued to minimize the horrors that he perpetrated that night. So it is important to have a complete and clear-eyed appreciation of precisely what he did, according to the judicial record. Claudia lived in her house in Cedar City with 2 daughters, Carol and Benita, and the 3 young granddaughters. Honie and Carol were not married at the time. Honie was living with another woman that summer of 1998 and only saw Carol, quote, on and off. At about 8 p.m., Honie told Carol over the phone to come over to his place. His other girlfriend was out of town, and he was alone and he wanted sex. Carol had to work at 10:30 that night, so she refused. Honie then told her that if she didn't come to his place, he would go to her mother's house, kill Claudia and Benita's kids, and take Tressa somewhere where they couldn't find them. Carol had heard Honie make threats like this before and not follow through on them, so she went to work. Claudia stayed at home with the 3 grandchildren. Honie then called a local taxi. The taxi driver picked Honie up at about 11:30 p.m. Honie told the cab driver to take him to Fiddler's Canyon, Claudia's neighborhood, and from there directed the driver to a parking lot near Claudia's house, where he got out without revealing his final destination. He walked the rest of the way. Around midnight, a neighbor heard what she thought were gunshots, which were in fact banging and crashing through the glass door. A man and woman were yelling. A woman was screaming. Children were crying. The neighbor called police. They arrived within minutes. They surrounded Claudia's house and saw glass broken out of the sliding door. Honie eventually obeyed repeated commands to come out of the house. He had blood on his arms from fingertips to elbows. When an officer asked where the blood had come from, he said, quote, "I killed her. I stabbed her with a knife." Once in the house, officers found Claudia lying face down in a pool of her own blood. Claudia's underwear was pulled down below her buttocks. Large amounts of blood surrounded her anus. She was dead. There was a butcher knife by her body and a rock on the living room floor that had been used to smash through the sliding door. Officers saw blood in several locations of the house, in a kitchen drawer, in the bathrooms, and on closet doors. While officers were in the house, two small children, Benita's children, came into the living room. After putting the children in a patrol car, officers looked back and saw the youngest girl, Tressa, standing in the doorway looking toward Claudia's mutilated body. TR and Tressa had blood on them. 4-year-old DR was covered literally head to toe with blood. Honie later told police that the blood came from a cut on his hand, but at least 3-year-old TR most likely witnessed the murder. TR's other grandma testified that when water spilled, TR would later say, "Grandma D, blood all over. Grandma D, blood butt cut." Honie would later admit, and the sentencing court found that he attempted to anally rape Claudia, but decided against it when he realized she was dead. Abused 4-year-old DR after murdering Claudia, causing painful abrasions to the hymen, oozing and bleeding. In light of what we know about his assault on another prisoner just last year, and his access to illicit amphetamines the year before, I'll discuss those more later, but as he stands before you today, claiming to be irretrievably broken, according to Reynolds, is not a terribly effective plea for mercy. Finally, Dr. Reynolds extensively discusses how, in Honie's view, Claudia verbally and emotionally abused Honie, enraging him. Her telling gives Honie a powerful motive to get revenge on Claudia. If true, this is not remotely exonerating. If false, Honie's claims are offensive to his family. This is victim blaming. Honie's new experts and his entire case before this board merely repackage evidence and major themes already presented at his 1999 sentencing hearing. And rather than hearing about these themes from academics, the sentencing judge heard them from firsthand witnesses who lived on the reservation. The sentencing judge's determination should not be second-guessed. The balance of aggravation and mitigation remains the same today as it did in 1999.
Mr. Honie, do you have a statement or just answer questions from the board if we have any?
I have nothing written. I didn't think it would be right for me to write something down and come talk to you guys. I appreciate you guys' willingness to hear this. I apologize that this magnitude of a hearing had to fall in your laps. I don't know how to begin. I don't know. I have discussed it with my daughter. How can I come over here and ask you guys to spare me? Because I'm her helper, I'm her guiding light, I'm her pillar. When I took that from the victim's family, she just now said that she would have been okay, and I agree. Had I not done what I did, there would have been a safety net for my daughter, for my granddaughter. I'm the one that took that, me, Taberon Dave Honie, who is a member of the Hopi tribe. I killed Claudia Ben, a member of the Paiute tribe. My daughter's grandmother, my ex's mother. Could I take it back? I wish I could. Am I proud of it? No. Am I making excuses? No. I had a whole thing prepared coming to talk to you guys today about how I've changed, the steps that I've taken to change my life. The individual that committed those crimes ain't the individual that's talking to you today. For the last 20 years, I've been going by culpability, accountability, responsibility. But no matter how much change I make, I can't make that right to that family, to their family. I don't know how they feel about it. It's still family. It's my granddaughter. It's my daughter's family, their family. Their feelings matter to me. I can't take anything back. I don't remember some of it, but the fact is, she's gone and I did it. I can't change that fact, no matter how much I want to. I was ready to come and argue the points of Judge Braithwaite's reasoning of giving me the death penalty. That don't matter. I'm to be held accountable because I did this. I'm not trying to minimize anything. I'm not trying to take away from Claudia's family's pain. I put the shoe on the other foot. I would feel the same way they do. I've read the declarations. Yes, I'm a monster. Yes, I'm a POS. The only thing that kept me going all these years is the only thing I know 100%, this would have never happened if I was in my right mind. That's the only thing that I know. 100%, that's for sure. I make no excuses. I don't know how to feel about pleading for my life. I've shown that I can exist in prison, no doubt about that. That doesn't erase what our family's going through. That's the biggest thing to me. My lawyers will tell you, I argue with them all the time. Don't make excuses. I did this. Am I proud of it? Hell no. Things that were done to Claudia shouldn't have been done. They didn't need to be done. I did those things. I don't know if it's gonna make a difference to you, the board, if intoxication, I know, that's why I threw that in there. I know this would have never happened had I been in my right mind. That's all I wanted to convey to you guys, to tell you guys. I appreciate you guys' willingness to hear me. Thank you.
Thank you, Mr. Honey. Do we have anything else?
If I could ask Mr. Honey a couple of questions.
Sure. Proceed.
Tate, can you talk about what it's been like in prison for you? The accomplishments, the sense of accomplishment maybe that you've felt while you've been in prison? You say you're not the same person, so I
Yeah, I
thought maybe you
think-
could share some of that with the board.
For 6 or 7 years when I first started this, when I came into prison, I did the usual thing of blaming someone else for all my problems. It was somebody else's fault that I'm in prison. I switched when I listened to a program and the lady was talking about repentance. And she was talking about metanoia from a Greek Septuagint. And what she talked about was true repentance, not only asking forgiveness for your actions, but actually changing your mind and your lifestyle. That hit a chord with me. From that time on, I did change. I purposely went out of my way to change how I think, to take responsibility for my actions. Minimal help from DOC because in their mind, they can't waste the resources on me because I may get executed. That didn't stop me. I kept going. My daughter's the reason I did most of it. No matter how dire a situation is, you can always find a light in there to do good. I don't know how, and I don't know if it's proper for me to say it like this, but if you'll excuse me and indulge me for a while on this, I call this the belly of the beast. Everyone in here is a POS. It's how we come out. You either come out fertilizer, helping things grow, or you just come out and be a mark to society or to whoever. I choose to be fertilizer, help people along the way. Got my diploma, all the things that, I mean, I can sit here and tell you guys about how we came out, how they let me out from Max and to go to employment to where a plumbing job to where it was the most trusted job in the whole facility. I've done plumbing work back there, back here. I've been in this building, you just haven't seen me. That doesn't matter to me, though. What matters is the magnitude of my crime. I can never take anything back from that. I don't know if I'll ever be able to rectify that. Family matters back there. My family matters back there. The thing about it is, they're all family. My daughter, my granddaughter ties us to Claudia's family. That's what I have to live with, and that's what I'm trying to better myself all these years. That's the part that I'm torn apart about. How can I come to ask you guys to spare me when I took her? I have no answer. Why should you guys spare me? I took Claudia. I don't have no answer on that one.
Does the board have any questions for Mr. Honey?
I do, Mr. Honey.
Yes, Mr. Yes.
Can you tell us what your standard level of intoxication would have been back then? Not just on the day of this crime. In other words, was this a regular level of intoxication?
No. This was starting the drinking at 8:30 in the morning, nonstop all day. Smoking, using whatever that came. My usual day is go get a day job, go work, come back home, get a 12-pack or 18-pack, drink it, pass out, wake up, go out again.
Okay, I want to make sure that I understand. Was it typical on every single day to reach a blackout point of intoxication?
No. Get drunk, pass out, yes. The point of intoxication is, as in dumbass, excuse the language, back then, I used to be proud of being able to go to the liquor store and drink a half pint of Everclear every day. That night that this happened, that day that this happened, We started at 8 o'clock. We looked for work, we couldn't find work, and we just started drinking and using drugs. Big ass party. It wasn't my normal routine or what we usually do.
Okay. What was your plan that night?
The day was like usual, get wasted and go pass out. That was my plan. Get wasted and go pass out.
Okay, at some point it changed because you got a taxi and told the taxi driver to take somewhere. Can you tell us what your plan was at that point?
So Carol, my daughter's mother, called me. She wanted to break up, and we broke up, and I was with another lady. Then she called me. We had a complex or a weird relationship. Sometimes she would call me and say, come over, I'm not going to work, or I'm going to work, and then go over, she's at work or she's not there. There's been instances where I've gone over and she's there, but she don't want to come out and she's sleep under the porch. You know, wake up next morning, she comes home, her and Benita come home, Carol's out there talking to me, then I go home. Go to the place where I was staying. Carol is, I don't want to sound like I'm putting blame or anything on her. I just want to be clear about it. We've gone through that a lot where she'll call and say, come over, then disappear. That night that this happened, I went over there to go sleep under the porch. If she's not there, I'm gonna sleep under the porch. I'll talk to her in the morning. That was the plan.
When did the plan change? Can you help us understand what led to this?
To the best of my ability, there's a lot that, and I'm not using this as an excuse. That pisses me off when it's said like that. I truly don't remember a lot of it. I don't remember why we got in an argument. All I know is we got in an argument. It's when Carol and I first got together, we met in a rehab here in Salt Lake City, Indian Recovery Center. At the time, it seemed like it was a good idea, but in retrospect, it was a bad idea. We're both in recovery trying to fix ourselves. She went to the Hope, my parents came up and picked us up in Cedar City, and we went to the Hopi Reservation. Then we went back to the Kaibat Paiute Reservation where Carol's from. A scenario like this, the instance that I'm in death row for is drinking all, we hit Kaibat, Benita wasn't home. So we went to the bar, we went to the liquor store, I started drinking heavily. We went to her stepmother's house, and that's all I freaking remember. And the next thing I know is the officers hooking me up off the mattress saying, you're going to jail, you beat up Carol. What? You beat up Carol. I don't remember anything about that instance, only what I read in the police reports and what Carol told me. So after that, I went to jail. Carol said, come back to Salt Lake. I came to Salt Lake. We became a couple again. And it's always been with the relationship there of when we're alone, we're good. When she's with her family, it's no, because they don't like me because of what I did to her. I understand that. I told her that. Then she got pregnant with Tressa. And from there, it was always come around for Tressa, my daughter. My original plan was on that night, go sleep under the, what do you call it? The steps, the landing, if you want to call it that. Spent some time with Tressa, and my thing was to go back to the reservation on the weekend. This wasn't planned. This wasn't meant to happen. He went from 0 to 100 like that. I'm assuming that's what we were arguing about, was the fact that how I beat up Carol. If that's what you're looking for the answer. I don't know if I clarified it enough, and I know I jumped around, but I wanted to give you the backlog of what we usually argue about, what they didn't like me for.
I wasn't looking for any particular answer other than your viewpoint on what happened.
I don't want to come across like I'm blaming anyone or I'm saying if this or no. I accept culpability, accountability, responsibility. I do know for a fact, and I said, I reiterate that if I was in my right state of mind, I know this would not have happened. I can't take it back. Claudia didn't need that stuff done to her. She's never hurt me in any way for me to do that to her. They never hurt me in any way to do that to her. I'm fully aware when I say the victim's family, my daughter and my granddaughter are involved.
Thank you for answering my question.
You're welcome. I hope I clarified well enough.
Mr. Honie,
Yes, Mr. Johnson.
tell me about your discipline history here in prison.
Not to sound flippant about it, I got a lot of knickknacks, if you want to call them that. I got a dirty UA, and that's how I lost my plumbing job in November 2022. Then I got a fighting write-up last year, July 29th. Those are the only two major write-ups that I have in the 25, 26 years I've been here in prison.
I have a note about an improvised weapon.
That's a weight stick.
Tell me about that.
It's used, a lot of the guys back here, they don't allow us the bars or anything, so we'll improvise and use magazines or newspapers, roll it up into a bar, then use that to do arm curls and exercise stuff,
Okay,
weight bags, water bags.
okay. But you did receive a write-up for that.
Yes, I don't even know if that was dismissed. I know I got charged for destruction of state property for ripping a sheet in that same write-up, but I can't remember if I got charged for that weapon or that weight stick.
Okay. And referring to the fight last year, can you tell me a little bit about how that evolved or what was the conflict?
So I don't know if you guys don't want names used, right?
No, I'm not asking about the names.
Okay,
Refrain
fine.
from using names, please.
Okay, so an individual, I was over in Barrel 4, Section 1. I was going over to get water. There was an individual that two older guys were having an argument with, telling him, "You're using too much vinegar. Quit spraying so much vinegar on the tables, you're burning everybody's eyes and nose." And he started verbally attacking them, saying they're old, they stink anyway, they need to go to current to pass on out of this life and all this other stuff. And I know those guys, so I said, "Hey, leave them alone, will you?" Then my friends on this side were on the phone saying, "Hey, can you let them know we can't hear on the telephone?" So I said, "These guys can't hear." And he started in on them again, and I said, "Just walk off." He said, "He don't have to do a damn thing. It's his effing section. If I got a problem with it, we can fight." Okay, so I put my cup down. He jumps up off his stool, comes at me, and reflex. I know I'm saying it like it sounds flippantly, but I'm not gonna let anybody come and smack me just to smack me. I slap, got his chin, he went down. Look to make sure he's okay. He's okay, he's getting up. Pick up my cup and I walk to my area. He comes around and said, it's not done. We're not done. Let's take this into the bathroom. Sat there, no, we're not gonna do that. It's when he was moved to swipe my desk. My TV and my food, everything's up there. That's why I said, hold on, okay. Stood up, started going to the bathroom, and one of the guys that we're programming with said, Honey, leave it alone. He's trying to get you in trouble now. Turned around, walked back, sat back down in my area.
So in hindsight, are there other ways or options you've
Yes.
thought about?
I've been back in Antelope Max for a year for that.
Mhm.
I've had time to think about that. It's, yes, I've learned all these ways of getting out of conflicts and alternative stuff. There's other ways to deal with that stuff. For a long time, I denied that this was on my mind. Yes, it did have a part to play in my dirty UA. Yes, it did have a part to play in me getting in a fight. I worry about my daughter. I worry about Claudia's family. 26 years I've been here. It's like yesterday. I can't stop thinking about it. I wish I could go back and change it. Yeah. That's the only thing that kept me saying all this time is to better myself, to help where I can. I was in my right mind. I would not have committed this crime.
Thank you.
Thank you. Ms. Sturba?
Mr. Honey, so just now, a few minutes ago, you said that you are a pillar for your daughter and your granddaughter. Can you help me understand what that looks like while you're incarcerated and what that means to you?
So I'm an addict and an alcoholic. In the 26 years I've been here, I've only had one dirty UA. I don't use. My daughter is just starting that journey. And the conversations we have, it's, well, I'm gonna give you the best advice I can because I've been through it. Her mom, unfortunately, is still in that world of using and everything. And right now, it's, to me, it's just me for her. From the start, it's always been her. I mean, when my direct appeal was denied, I was gonna drop my appeals. My daughter said, no, I need you. When my appeals were from the state courts were denied. So my legal team, I'm gonna drop my appeals. No, my daughter said, no, I need you, Dad. Now we're at this stage, and like I said, I don't know how I can come and ask you guys, spare me when I took Claudia. When I took their pillar. I did that. But I owe it to my daughter and my mother to come ask if there's a possibility. The individual that you're talking to today isn't the same person that I was back then. I made those changes. That's how I want to be. That's how I am a pillager, helping her through her journey.
Thank you for answering my question.
Thank you.
Mr. Yates?
Mr. Honey, I have just a few questions for you. The information I've reviewed indicates that you actually called Carol. You initiated the phone call before you went up to Miss Penn's house. Is that correct?
She called me.
Okay. And did she say what she wanted at that time?
No, I shouldn't say she called me. I'm going by what was said in court. She called me because she didn't hear from me all day and she was calling to check in on me.
Did you get into a heated discussion with Carol?
almost every single conversation, it's heated.
And help me understand why you would go up to the house of the victim, because it's my understanding from my review of the records is that Carol told you she couldn't see you because she had to go to work. Is that consistent with your memory?
Yeah, the thing, Mr. Yates, is she said that before. And when I went over there, she'd be there, or she'd come pick me up, or she'd go to mutual friend's house saying she's going to work, drop Benita off, go pick up our friends, then go to Arizona, then come back before the night's over. So it's one of them things where my mind may be playing tricks on me, but that's what we've done that before, where she tells me she's not gonna be there. I go over, she's there. There's been repeated things like that. I mean, I called one time and talked to Benita, and she told me Carol's not there. And when we showed up, she wasn't there, but she pulled up and she used to tell me to come around.
During your course of conversation with Carol,
Okay.
at any time, did you threaten to kill Miss Ben?
I don't, no, I don't recall that, but I'm not saying that didn't happen. I've said that in the past to her. I'm here to be honest and forthright with you, okay?
Thank
That's
you.
the only way you guys can see the true picture. I talk a lot of crap. And yes, I said that. I'm gonna kill everybody and come over there, and I didn't mean it.
Were you aware that 3 of the victim's grandchildren were living with her at that time, including your own daughter?
My daughter is one of the 3.
Right.
Yes,
You were aware all 3 of those
yes,
children, I think they were ages 4, 3, and 22 months at the time.
yes.
So when you went to the house, why didn't you just go to sleep under the porch? How is it you
She
started?
heard me.
She heard you?
Yes.
And then what happened?
We got in, there's been instances where I went over, she heard me and she called the cops on me. There's been instances where I went over to watch a movie and then they asked me to leave and the police had to escort me off. Actually, it was an officer that lived down the street that said, "I'll take you to town." That's what I was trying to say is the relationship we had is my daughter's mother would say, "Come over, spend time," knowing that her sister and her mom and them didn't like me for what I did, because I beat her up.
Sure.
But she'd still say, "Come over," and we'd sneak around. When I first went to Cedar City, it was Betsy's house that she allowed me to stay in her house, but for a certain time. After that time limit ran out, then Carol said, "Well, okay, start sleeping outside." Then Betsy caught me out there.
So you got into a verbal confrontation
Yeah.
with Miss Ben. And then
I don't know
Yep.
what for.
at what point did you decide you were going to break into the home?
That I can't tell you, Mr. Yates.
Do you remember breaking into the home?
No.
Do you remember entering the home?
I remember grabbing a knife from her. That's how the cut to my hand happened.
She had a knife in her hand?
Yes.
Okay. Do you remember seeing any of the grandchildren?
No.
But you were aware they were living there, is that correct?
Yeah, I was aware they were there.
And did you break glass or a door to get in?
That's what they say.
Do you have any independent memory of that?
Not fully, and I'm not saying this to make excuses, but there's a lot of it I don't remember.
That's fair. So at any time, when you're breaking into the home, did you think, I wonder what impact this might have on those 3 children?
No,
Never crossed your mind?
never crossed my mind because I wasn't in my right mind. Had I been in my right mind, there's no way in hell I'd have broke that window. What ifs is I played that game all this time. What if, could have, should have. I know for a fact Was in my right mind and we argued, I would have waited for the police to come to take me to jail.
Okay.
There's no, I didn't. This wasn't planned. I didn't go over there to kill Claudia.
But at one stage, you had the wherewithal to call a taxi to take you there. Is that correct? Do you remember that?
No, because I didn't even have money. I don't remember where I got the money from.
So you don't remember traveling to the victim?
With, no. With, the taxi driver, I remember getting in and getting out, giving him my $20, waiting for him to give me my change back.
All right, that's all I have. Thank you for answering my question.
You're welcome, Mr. Wade. So hopefully I clarified. If there's anything else that you guys need, because I'm here to, this is my, put everything on the table. I've been going to court all this time just to try to get it in front of a jury so they can see both sides, not just what I told Nancy Cohen, you know? Half of that, what I told Nancy Cohen is I thought I was getting out. I'm not making excuses. I'm just saying what it is. Right now, I'm like clear mind. I want to make sure that you guys know where I'm coming from. Because like I said, it took me a long time to finally grow, to mature, to see the magnitude of the crime I've committed. And like I said, I apologize that it fell into you guys' lap to decide this.
Yeah, please, Mr. Hills.
Can you explain what you told Dr. Cohn that was not the truth?
I'm not understanding your question.
Sure.
Fine, say
I
it.
may have misunderstood you. It sounded like you said half of what you told Dr. Nancy Cohn was just nonsense because you thought you were getting out. So my question is what you told Dr. Cohn accurate, or was it just nonsense that you were making up?
No. My legal, and I don't know if we can, I mean, I've read the rules that you guys put down, and I was told by legal counsel, my defense team, that if I just go along with what the state put out, that Robert Braithwaite, the judge in Iron County, he's a young judge, he's never heard a death penalty case before, and he won't give me the death penalty. It's either a matter between life with parole or life without parole. Life with parole because of my age, and it's the first time I've been in prison and all this other stuff. I'll get 1 to 15, I'll do 25 years, and I'll be eligible for parole after 15, and I'll get out after 25. So when I was talking to Nancy Cohen, it was, okay, let's do this. What happened? What did they say happened? Okay, that's what happened.
So I want to make sure I understand.
But I'm not taking anything away. I'm not trying to say the crime didn't happen. It did happen. I'm not trying to say, no, this didn't, it did happen. I'm the one that did those things. I'm the one that took Miss Ben's life. Am I proud of it? Hell no. Was it planned? Hell no. Sorry for using that language, but no, it wasn't planned. That's the only thing I can say to you about what the state relies on so heavily is Nancy Cohen's testimony. Well, that testimony, or that what she got from me was because I thought I was getting out. And now, 26 later, I won't even be asking you to let me out of prison. I lost that right. I lost any hold I had on society when I committed my crimes. I earned my place in prison. And what I'm asking today, this board to consider is, would you allow me to exist? I've shown that I can exist in prison. I'm not a threat to the public. I'm not a threat to anyone. My job as a plumber, as I said, the reason I brought it up is I've been back there around the board, around and in Draper. I've been to there. I've been to every building in this compound. 80% of the staff don't have a problem with me. When I was a maintenance worker, even single females would take me down to the maintenance shop at 1 or 2 in the morning. No worries. The crime that happened is not me. It's something I did, but it's not me. Hope that kind of makes sense.
You tell me a little bit more though, because I don't want to guess at what
Okay.
you're thinking. I want to make sure that I understand you.
Okay?
Do I understand correctly that Dr. Cohn asked you questions and you're telling us today that instead of answering with what you knew, you just told her things to get the interview over with that you didn't know or weren't true? Can you explain that to us?
I don't want to take away from the fact that I am taking responsibility for everything that happened. What I'm trying to clarify with Nancy, what happened with Dr. Nancy Cohen is a lot of it, that was geared toward, hey, my attorneys told me if you do this, you'll get out. A lot of it, I don't remember. A lot of it, I don't trust my memory to try to remember. That's what I was trying to convey to you is, if there's specific points, ask me, because then when I talked to Nancy Cohen, some of it was, hey, they said this happened. Is that what they said happened? Okay, that's what happened. But I'm not telling you guys today, no, nothing happened. No, it did happen.
Thank you.
Does that make sense?
Mr. Stevenson.
I understand your position. Thank
Okay.
you.
Thank you.
We have another question for you, Mr. Yates.
Um, Just very quickly, Mr. Honey, is
Great.
there anything that you would like us to know about you or your situation that we haven't already talked about that you think we should know about as a board?
I'm not sure how to answer that, Mr. Yates. As I stated from the start, I was coming up to not really tout my record, but show you guys that I'm not a danger to society. I'm not asking this board to let me out of prison. I'm asking this board to allow me to exist in prison because I've shown that I can. If I won't, I take full responsibility, accountability, and responsibility. I'm not saying I didn't do these crimes. I'm saying, yes, I did. The only thing I can say, now you asked about what we haven't talked about. If you allow me just to reiterate, if I was in my right state of mind, this would have never have happened. I know that for a fact. That's the only thing I know for a fact.
Thank you.
You're welcome, Mr. Yates. Thank you.
That's all I have.
Any other questions? Thank you, Mr. Honey.
Thank you, guys. I appreciate it.
If I could just
Counsel?
clarify for Mr. Johnson, he asked about the weapons charge against Mr. Honey. If you look at the state's exhibit 7, pages 44 and 45, Mr. Honey was found not guilty of that particular charge, and it was based on actually what he said. The notation is, while the water stick may be used as a weapon, it is institutionally accepted that inmates construct these items to lift homemade weights. I do not believe the water stick was crafted to be used as a weapon, and he was found not guilty.
Counsel?
That is the end of our presentation.
Mr. Honey?
if you allow me to say another thing, it just came into my mind. The
Proceed.
presentation that was made this morning by Victoria, Dr. Reynolds, when she was going through her presentation, I could not stop thinking about my daughter and her two cousins. The trauma that she presented that I went through, my daughter and her two cousins have to go through that now. I'm grateful that they didn't turn out like me. They're going into their 30s and they haven't been to jail. They're living as best they can. On record, I want to ask them, apologize. Hopefully one day you'll forgive me.
Thank you, Mr. Honey.
Thank you for letting me speak.
Okay, we'll be in recess till tomorrow morning. That concludes our hearing today.
In light of what we know about his assault on another prisoner just last year and his access to illicit amphetamines the year before, I'll discuss those. Honie also relies upon the support of his family, and we heard from Honie's family members yesterday. We are not unsympathetic to the anxiety and pain Honie's family, that this execution would cause Teresita, Tressa, Carol, and other family members. But the sentencing judge already considered Teresita's pleas for mercy in 1999, and the court expressly considered that Tressa would be growing up without a father. Yet, due to the 25 years of litigation, Honie has been able to see his daughter grow to become an adult. He got more time with her than the sentencing judge anticipated. The sentencing judge anticipated that this process would take only 15 years. He's had 25 years to see Tressa grow up. And the family support is simply not sufficient to overcome the wanton brutality of Honie's crimes. Honie's violence and criminality go past the single murder of Claudia as a mother and a grandmother. The judge imposed a sentence not just for his crimes against Claudia Ben, but also for his crimes against society as a whole. And Honie's family support is not as straightforward or as uncomplicated as it might first appear. He relies on the support of his family, but he blames his parents and siblings to some extent for his behavior. And I'll leave that complicated reliance to this board's discretion. The final portion of my argument today will discuss Honie's claims of remorse. Honie's claim of remorse before this board should be considered in light of his consistent deflection of responsibility since his first interviews with police and continuing into his petition for commutation in the case presented to this board. He's auditioned various narratives and excuses over the years, including to this panel yesterday when he testified. In his first police interview, Honie would not admit to what he had done, claimed that he had blacked out, talked about another person being involved in the murder. When the interviewing officer first walked into the holding cell and before the officer could say anything to Honie said, quote, Claudia was not supposed to die. Honie said he only wanted to scare her. This despite clear and declared intent to kill Claudia by calling Carol and announcing his intent before killing Claudia. He said he was sorry and should die for what he had done, but he did not know, quote, what the hell he had done. He said if he killed Claudia, he was very, very sorry. Quote, God, please forgive me, and quote, D, please forgive me. He said he could have killed Claudia. He said that he had done something bad, but he did not admit to the murder. In the second and third police interviews, Honie blamed Claudia and said she started an argument by cutting him down and calling him a lot of names. Honie claimed his emotions eventually came out and he broke the glass door and went into the home intending to scare Claudia. Again, intending to scare Claudia. Honie also claimed that Claudia got the knife, but he grabbed it from her. He then asserted that he moved behind Claudia and brought the knife to her throat. At that point, according to Honie, they fell on the knife, and I've already discussed why that's implausible. It just is patently untrue. Even in 2024, when interviewed by Dr. Reynolds, Honie told her that he was blacked out and remembered very little of what happened. This is directly contrary to what he told Dr. Cohn in 1998 or 9. She testified at sentencing that Tony told her the whole story and only wished he had blacked out. He said he only wished he had drunk more so that he wouldn't remember what he had done. Honie's commutation petition is one long deflection of responsibility for his crime, and we've gone over that in our response to his petition. But I'd like to note that on the very first page of that petition, he uses the passive voice to say that, quote, he became involved in a domestic dispute, tragically taking Miss Ben's life. He repeats this theme of the murder being a domestic dispute several times during the petition. He reasserts the lie he first told officers in 1998. I don't know what the hell I did. I could have killed her myself. I don't know. If I did, I'm very sorry. He nowhere acknowledges his sexual abuse of 4-year-old DR, and instead notes only that the guilt-phase jury did not find it as an aggravator. He omits that the sentencing judge expressly found it to be an aggravating factor after hearing the penalty phase evidence. Before this board yesterday, Honie testified that half of the things he told Dr. Cohn were just him going along with what his defense team told him to do to get a life sentence. If that is true, then it shows that Honie is willing to say whatever he needs to say to escape judgment, including to this board. Honie also said multiple times yesterday that, quote, he wasn't making any excuses for what he did, but he said several times, quote, if I was in my right mind, this wouldn't have happened. That sounds like an excuse to me. And Honie, by his own testimony, drank heavily every day. He said at one point that he drank a 12 or 18 pack a day in the time leading up to the murder. He also said that he drank half a pint of Everclear a day. It is reasonable to assume that Honie's tolerance for alcohol was very high. And importantly, Honie chose to get drunk and high that day. He made the decisions that put him in an intoxicated state. Yesterday, Honie recalled the phone call with the phone call with Carol preceding the murder, but he claimed he did not remember telling Carol if she didn't come to his place, he would kill her mother and Benita's children and take Tressa away. He could remember the phone call, but he couldn't remember that detail. He admitted that he was aware that grandchildren were in the house, and he said he remembered grabbing the knife from Claudia, but he claims he doesn't remember breaking through the sliding door with the rock. He claimed he didn't remember the taxi drive to Claudia's house yesterday, but he later said that he remembers paying the taxi and receiving change for it. Honie also testified that he should be given life because he has, quote, chosen a life of helping people But he did not point to a single charitable or helpful act outside of his plumbing work and his discussions with his daughter. Plumbing is an occupation for him. It's not an act of generosity or charity. While Honie claims that he is sorry for what he did to Claudia's family, he also said, quote, "The crime that happened is not me." This does not sound like taking full responsibility for what he did. Honie also said he's a pillar for his daughter Tressa because he tells her about his alcoholism and his abstaining from alcohol. She is having substance abuse issues now, and we sympathize with that. But Honie took away Tressa's grandmother, a substance abuse counselor who helped many people with these issues. This is a grandmother who could have helped Tressa with her recovery. On balance, and considering Honie's in-person statements to this board, we submit that Honie has only very partially taken responsibility for his actions, and only when it is convenient or in his view necessary to do so, to escape punishment. That is tactical. It's not real remorse. And finally, what remorse Honie has shown is vastly overshadowed by the devastation he caused Claudia, her family, her friends, and her tribal community. In closing, Honie's death sentence has survived decades of intensely searching judicial review. It comes to this board as a presumptively valid expression of society's judgment of what Honie deserves. If he is to persuade this body to extend him mercy, he must show a compelling reason why he deserves it, despite originally deserving death. But Honie hasn't shown any compelling reasons. At most, he has shown why he thinks he never deserved a death sentence to begin with. The board should reject that framing. The sentencing judge weighed materially everything Honie says merits mercy and judged the case in aggravation to outweigh Honie's reasons beyond a reasonable doubt, independently found that death was justified and appropriate beyond a reasonable doubt. Honie's case for commutation is not strong. It's weak at best, adding nothing new, adding only additional immaterial color to what the judge already knew in 1999. And it does not alter the balance of aggravating and mitigating factors that the judge struck at that time. Balance remains the same. Honie deserved death then, and nothing has changed. We urge you to give Claudia, DR, the Paiute tribe, Claudia's friends and family, and the people of Utah, give them the justice that they deserve and have been waiting decades for. We ask that you deny commutation and let justice be served for Taberon Honie. Thank you.
Board has some questions. Ms. Sturba?
Thank you for your presentation. So Article 7, Section 12 of the Utah Constitution specifically authorizes the Board of Pardons to consider clemency relief. The legislature has reviewed and considered this constitutional grant of authority, and in 7727 5.5 has limited that authority to a consideration only of a death sentence to a life without parole sentence. So, and as you have very clearly and articulately stated, the state's position is that this is not an appropriate case for commutation or clemency consideration. Is it the state's position that the board should never consider commutation and never exercise this authority?
No, not at all. Not at all. The commutation question is reserved for compelling reasons, new and compelling reasons. And I think that's borne out by statute and by the rules. If there certainly could be a case where substantial rehabilitation, redemption, coupled with some new fact that perhaps could not have been discovered with reasonable diligence in earlier time to be presented before the board, that could warrant commutation. So it's not our position that commutation would never be warranted.
So you kind of already anticipated my next question, but you talk about kind of substantial rehabilitation, some new fact. What is a case that is appropriate for commutation consideration?
I would have to see it to know. I don't have a hypothetical or an example to provide the board at this time.
Can you define for me the state's position about what substantial rehabilitation would look like?
Um, an immaculate record, an immaculate record, specific acts showing that a prisoner has gone above and beyond the circumstances of prison life and charity, something above and beyond. Well, certainly something that would help, specific instances that would show helping someone.
I appreciate that answer. In your presentation, you talk about kind of how the balance of aggravating and mitigating factors has not changed since the sentencing court considered them in 1998. Is it the state's position that the board and a trial court are kind of similarly positioned in their respective authorities to review and consider cases?
I think the positioning is different. The sentencing judge is the fact-finding body, finding facts in mitigation and aggravation, and then finding beyond a reasonable doubt that one outweighs the other, and then making an independent finding as to whether death is appropriate and justified under the circumstances. The board has broad discretion to review the new evidence, including the record as well, in making its decision as to whether a petitioner merits mercy. But in my understanding is, the legal conclusions drawn by the sentencing court, legal conclusions are certainly under the statute non-reviewable or not to be interrupted. Yeah.
Thank you.
Mhm.
And then finally, yesterday we heard from Taberon Honie, who was, I think, undeniably a direct victim of this offense. She was there. She was 22 months old, who has, stated that she will suffer additional loss and suffering if we deny the petition.
Mhm.
How is the board to kind of reconcile visiting additional grief and loss on a victim?
Mhm. Yeah, I observed Tressa's testimony as conflicted. She's a granddaughter of the victim. She's also a daughter of the defendant petitioner. So she's in a very conflicted place. I don't think her testimony went one way or the other towards commutation or death, given her conflicted position. And we sympathize with Tressa and that position that she's in. But again, my view of that testimony yesterday was that her position could not readily be determined. So I would defer to this board's discretion in weighing it, but that's my view.
Thank you for answering my questions.
Any other questions from the board? We are on the record. All right, the remainder of this hearing will be turned over to the petitioner's counsel for closing remarks.
Chairman Stevenson, Vice Chair Sturba, and members of the board, we thank you for the opportunity to come here for today and yesterday to present Mr. Honie's petition for commutation. Mr. Honie is here today asking for your mercy and your grace. This request is something he has struggled with because he believes he is deserving of nothing. Yesterday, he told you, I don't know how I can come here and ask you to spare me when I took Claudia. He's not asking to be let out of prison, nor does he think he deserves it. He told you yesterday, I lost that right. I lost any hold I had on society when I committed my crimes. I earned my place in prison. What I am asking you today to consider is, will you allow me to exist? He's asking you to allow him to live so that he can continue to be a part of the lives of his daughter Tressa and his granddaughter Alana. He is asking you to allow him to live so that they and the rest of his family do not suffer more than they already have because of his actions. Yesterday, you heard from his mother, Teresita, who told you about her love for her son and how she has already lost one child and losing another one would be unbearable to her. You also heard from Tressa, who talked about the loss of her grandmother and what that meant to her, and that Mr. Honie is her only parent now and she doesn't want to lose him too. Mr. Honie has been a positive influence on both Tressa and Alana and has been especially helpful to Tressa in her own efforts at sobriety. He is close to them and losing them would not only be devastating to them, but another act of violence that Tressa will have to learn to live with. Tressa is close to both sides of her family and has in a way been caught in the middle here. However, she came here yesterday to speak on behalf of her father. It was difficult, but she came in support of his plea for commutation. Yesterday, we shared with the board Mr. Honie's personal history and background through the testimony of Dr. Reynolds. We shared this with you not to excuse Mr. Honie's actions. Mr. Honie believes, as he told you yesterday, that there is no excuse for his crimes. We shared this with you to give you a full picture of his life so that you can understand how he came to commit these horrible crimes and how he is not now the person who committed these crimes 26 years ago. Mr. Honie told you yesterday that when he first entered prison, he made excuses and he blamed others. Then he decided to accept responsibility and to be accountable for his actions. From that moment on, he worked on himself to be the person who he is today. Tate wants to continue to better himself and to help where he can. Mr. Honie has a personal history that is remarkable for the extensive trauma he experienced in his childhood and young adulthood. These experiences affected his development, including his brain development, as Dr. Reynolds explained during her testimony yesterday. The difficulties Mr. Honie experienced in his life began before he was even born, as his mother likely drank alcohol during the time she was pregnant with him. Dr. Myers found in his report that the type of executive functioning deficits found in Mr. Honie were consistent with prenatal alcohol exposure. This was exacerbated by the many traumas and traumatic neglect he experienced as a child and young adult. Mr. Honie was born to parents who were highly preoccupied and impaired as a result of their alcohol addiction. They were often away from the home, leaving their older children to take care of the younger children. Mr. Honie was never able to develop an attachment to his parents because of this, which had lasting effects. He was mostly cared for by his older siblings during this time, who also had their own struggles due to their life circumstances. They also were not able to take adequate care of him and were insufficient substitutes for his early attachment needs. By the time Mr. Honie was 8, his older sibling caretakers were also abusing alcohol themselves. We heard from Dr. Reynolds yesterday that when Mr. Honie was old enough to walk, he would leave the family home for hours with no adult supervision. He wandered around the mesa, playing in garbage and ash piles. He would go for weeks without being bathed or having clean clothes. He was often referred to as the dirty boy in his community. His parents were repeatedly told by others in the community to take care of their kids. His parents often fought over their drinking and infidelities, which was a constant source of fear, helplessness, and extreme stress for Mr. Honie as a child. He also witnessed his mother attempt to take her own life with a gun during one of her arguments with Franklin. Dr. Reynolds stated in her report that the suicide of a parent is one of the most extreme manifestations of parental abandonment a dependent child can experience, and Mr. Honie witnessing the suicide attempt had lasting effects on him. Mr. Honie's siblings shared how severe and distressing their parents' fights were and how it negatively impacted them. Many of them have struggled with depression and addiction. They have also struggled to maintain intimate relationships and employment. Mr. Honie's mother left the family home on at least 2 occasions after fighting with Franklin. On one occasion, she lived at her mother's home for approximately 3 months. She remembers once looking out of the window and seeing Mr. Honie looking back at her. Teresita told him to come inside. It's okay. You can talk to me. Teresita left the home again on another occasion, but only for a couple of weeks. Franklin, Mr. Honie's father, remembers Mr. Honie crying at night when his mother wasn't at home because he missed her. Dr. Reynolds told the board that the brains of children exposed to trauma and traumatic neglect, to the degree that Mr. Honie showed differences in their brain development and their functioning. The psychological impact of such negative results in children feeling not only anxious for the well-being of their parents, but feeling abandoned, unwanted, and unloved. These feelings in Mr. Honie were only made worse when he had been told from a young age that his father was not his biological father. Mr. Honie asked Franklin about this, but his father never responded to him. This added to Mr. Honie's feelings of sadness, rejection, and confusion. It made him feel like an outsider in his own family and that he didn't belong. Mr. Honie sought comfort by spending time with 3 elderly women on the mesa who he referred to as his grandmas. Mr. Honie described this as trying to see where he belonged. Sadly, one by one, as Dr. Reynolds testified yesterday, all 3 women passed away, leaving Mr. Honie grief-stricken and resolving never to get attached to anyone after that. Mr. Honie also witnessed his parents being involved in a serious vehicle accident on the mesa. His parents were driving home and were struck by a large garbage truck that had lost its brakes going down the hill. Mr. Honie ran down to the road to the mesa to find his father covered in blood and having a seizure. His mother was trapped between the seat and the steering column. Mr. Honie's brother describes that Mr. Honie was so distressed that he was running around in circles and crying and screaming. He had thought that he had lost his parents. The experience of almost losing his parents was so terrifying and painful that Mr. Honie withdrew into himself. He blamed himself for the accident and attempted suicide shortly after. By the time the family had moved from the mesa to their new home in Palaca, Mr. Honie was spending little time at home and lived outside on his own with friends or sometimes in cars by himself. Mr. Honie was also born into extreme poverty on the Hopi Reservation. His early medical records suggest he suffered from many obvious manifestations of poverty and traumatic neglect, including bouts of scabies, impetigo, upper respiratory infections, ear infections, and pneumonia. The family of 8 lived in a 2-room home on First Mesa that had no electricity, toilets, or running water. Mr. Honie lived with his family in this home until he was 12 or 13 years old. As Dr. Gilbert testified yesterday, there were no activities for children when Mr. Honie was growing up on the reservation. Dr. Smith notes in his report that Mr. Honie told him, "We had no recreation center, no after-school activities, nothing. We lived at a poverty level below the city slums. We all had a view that I will never amount to anything. I will never be able to leave the mesa, so what's the point? I will always be looked down upon by others, and they will be better than me." Dr. Reynolds explained to the board that while the negative impacts of poverty may be buffered by parental attachments and a stable, loving family or access to resources outside of the family, this was not the case for Mr. Honie. His parents neglected their responsibilities, they drank and fought with each other. There also was no privacy in the 2-room family home, so the children were unable to escape and hide from witnessing their parents' dysregulated behavior. And outside the home, Mr. Honie was surrounded by other Hopi families living in similarly poor conditions who were demoralized by poverty, unemployment, and alcoholism. Yesterday, Dr. Reynolds analogized childhood traumas to barbed wire, saying that like a young tree that survives the close proximity to a barbed wire fence, by incorporating the barbs into its trunk and altering the direction its growth takes thereafter, Mr. Honie was wrapped in the barbs of extensive traumas when he was a child and young adult. This affected his development, including his brain development, and was directly linked to his alcohol and substance abuse. Today, Mr. Honie lives surrounded by the barbed wire of the prison. He will never escape this, but he has found a way to live a productive life and to be of use to others. And he will continue to do this if you let him. Mr. Honie's own history is also the history of his community and his ancestors. This multi-generational cultural history has had lasting effects on all of the Hopi and Hopi Tewa people. With respect to Indian boarding schools, The Hopi consider this to be part of their living history, meaning that, and I think Dr. Gilbert explained this, it's not something that just happened in the past. It continues to have lasting effects in their lives today. As Dr. Gilbert explained, it's very much ingrained in their lives today. Dr. Gilbert spoke about Indian boarding schools as a way to assimilate the Hopi to white culture. Children, including Mr. Honie's parents and older siblings, were removed from their families and sent away, often out of state, for many years, some more than a decade, before ever returning back to the Hopi reservation. They lost their culture, their language, their identities. The boarding schools were not focused on raising doctors and lawyers and community leaders. They focused on industrial trades, creating an Indian working class. Male students were sent to farms to work, and female students worked as domestics and nannies for white people. The boarding school kept their salaries and only gave a small fraction of the income to the students, effectively using Indian students as slave labor. Students were never able to learn from their parents, their aunties, their uncles, or other village members. In the case of Mr. Honie, by the time his parents were raising their own children, they didn't have the parenting examples from their own childhood to draw on. Mr. Honie has a long history of alcohol and drug abuse. It's not uncommon for children of alcoholics to become alcoholics themselves, especially when the mother drank during her pregnancy, as Teresita believes she did. In Mr. Honie's case, these factors, as well as his chaotic and traumatic home life as a child, likely led to his alcohol and drug abuse. Mr. Honie has an extensive history of alcohol and drug abuse, including drinking beer and wine and distilled spirits, using marijuana, hash oil, marijuana laced with other drugs, PCP, LSD, mushrooms, inhalants, methamphetamine, heroin, Vicodin, codeine, Valium, and other pills. Mr. Honie first consumed alcohol at approximately the age of 5, when he took one of his father's beers from the refrigerator. By the age of 10, he was drinking beer, whiskey, and wine with his peers. He also began abusing marijuana at the same age. After this, he began using inhalants. By the time he was 12 or 13 years old, he and his friends were using cocaine, methamphetamine, heroin, marijuana, and alcohol. He abused alcohol and other drugs daily until he was arrested for this offense. Alcohol abuse was normalized in his family and society, which predicted his own use. In her report, Dr. Reynolds states that Mr. Honie's early caretaking is notable for the extreme degree to which the vast majority of his caretakers, parental figures, and role models were impaired by alcohol on a daily basis. Not only were Mr. Honie's parents affected by their alcohol addiction, many of his aunts, uncles, members of his extended family, and virtually every one of his 5 siblings struggled with alcohol and substance abuse. Additionally, as Dr. Gilbert noted, during the time Mr. Honie was growing up, alcohol use on the reservation was prevalent. Dr. Reynolds reports that the multi-generational devastation that alcohol addiction has wrought within Native families and across the entire Native communities for almost a century is an epidemiological, cultural, medical, and mental health crisis that has been empirically documented and which is widely recognized. Therefore, Mr. Honie's lifetime substance abuse was not an individual phenomenon subject to his individual vulnerabilities or control. Mr. Honie's chronic exposure to trauma also predicted his substance abuse. Dr. Reynolds stated in her report that Mr. Honie drank and used drugs as a way of avoiding and numbing the ways past trauma impinged on his mind and his emotions. He told one expert that when he drank, he always drank to get drunk, to deaden the nerves and the BS. He repeatedly stated that his substance abuse was a manifestation of his hopeless, passive suicidality, his state of living to die. His addictions and substance abuse persisted for 23 years, despite participation in 2 residential substance abuse programs, in part because Mr. Honie's underlying trauma-related anger, depression, despair, and hopelessness that drove his addictions were never addressed. Mr. Honie's substance abuse history, while severe, is a recognizable phenomenon within a substantial subset of male trauma survivors, according to Dr. Reynolds. Research on the long-term individual psychiatric consequences, health risk behaviors, and public health concerns associated with childhood maltreatment and abuse have been identified have identified substance abuse in a significant proportion of adults who experienced adverse childhood events of the kind that Mr. Honie did. In her report, Dr. Reynolds states that this is because children exposed to trauma and who are left to cope on their own with the intolerable physical and emotional impacts of such traumas will necessarily find ways to numb, avoid, and otherwise manage the biologic and emotional dysregulations that occur as a result. The chronic hyperarousal, the massive influx of stress hormones that accompany repeated episodes of exposure to violence cause the nervous system to lose or never fully develop the ability to calm itself down or to suppress unnecessary fear or numbing reaction. In the non-traumatized brain, after a period of danger is over, and Dr. Reynolds explained this yesterday, the brain will signal the body to begin to suppress the fear response and return to its normal state. In the chronically traumatized brain, however, the initial fear reaction persists, and it becomes increasingly difficult to calm the fear response, and other emotions such as intense sadness, misery, anger become dysregulated. This opens the door for many children and adolescents exposed to trauma to seek emotional relief and behavioral modification starting at a very young age by using substances, as was the case with Mr. Honie. Not only did Mr. Honie's familial, genetic, and cultural vulnerability to substance abuse function as a powerful risk factor for his own potential for substance abuse, but his early and relentless exposure to trauma throughout his childhood and adolescence loaded the physiological and psychological cards against him and made it practically inevitable that he would not only seek out substances, but that he would also become addicted to them. Mr. Honie was extremely intoxicated at the time of his crimes. He had been drinking and smoking marijuana throughout the day and evening of the crime. He told his counsel that on the day of the incident, and actually he told this board yesterday, that he began drinking that day at 8 a.m. He had consumed 2 18-packs of beer with a friend. He smoked marijuana. He drank hard liquor over the course of the day. He used methamphetamine and later drank more beer and hard liquor. While Mr. Honie had no memory of the events after this, he was told that he also smoked PCP and then passed out on the lawn of the home where he was staying. Mr. Honie did not remember being advised of his rights by the police, and his mind was not clear until 2 days following the incident. At Mr. Honie's preliminary hearing, the cab driver, Rick Sweeney, testified that he had picked up Mr. Honie at 11:40 p.m. that evening and could tell that Mr. Honie had been drinking and was intoxicated. When questioned by the police about picking up Mr. Honie, Mr. Sweeney told them that Mr. Honie had too much to drink and was really drunk. Police officers at the scene of the crime also smelled alcohol on Mr. Honie and testified that Mr. Honie had made bizarre statements at the scene. Officer Robinson testified that he could smell alcohol on Mr. Honie from 2 feet away, and Officer Griffiths also smelled alcohol on Honie's breath. The police took a blood sample from Mr. Honie and submitted it to be tested for alcohol and THC. The testing revealed that Mr. Honie's blood alcohol level was 0.07 4.5 hours after the crimes. The blood test also revealed the THC in his blood both active and metabolized. No testing was requested by the police for methamphetamine or PCP. William Johnstone, a forensic chemist and toxicologist whose report is in the materials for the board, later performed a retrograde extrapolation to determine that Mr. Honie's blood alcohol level at the time of the incident was actually 0.15%, which was higher than the police lab report had indicated. Mr. Honie was also seen by an emergency room doctor several hours after his arrest for the deep cut to his hand. Dr. Stoltz stated that it was his opinion that Mr. Honie was highly intoxicated even at that time. He looked intoxicated, he smelled intoxicated, and he acted intoxicated, he stated. Dr. Stoltz also stated that Mr. Honie was marginally responsive and answered my questions in monosyllables and could not tell him what had occurred within the past few hours. Dr. Stoltz believed that Mr. Honie was not of sound or composed or lucid mind at the time that he examined him. This crime would not have happened but for Mr. Honie's extreme intoxication from alcohol and drugs, as well as his traumatic childhood, which impacted his brain development and ability to control his behavior. In his report, Dr. Smith diagnosed Mr. Honie with psychological disorders as well as drug and alcohol dependency. He states that Mr. Honie used a variety of drugs and alcohol, which impaired the functioning of his nervous system, resulting in mood swings, poor impulse control, difficulty with attention and concentration, disrupted processing of information and sensory input, poor judgment, difficulty with decision-making, aggressive behavior, and distorted perception and memory. Mr. Honie had an extensive history of abusing these substances in combination. He progressed from an adolescent and involved alcohol and numerous other drugs. Eventually, he came to prefer alcohol and marijuana as his escape, and stimulants to help him remain vigilant and remain awake, which was also described by Dr. Reynolds yesterday in children who have trauma. Dr. Smith found that Mr. Honie never had a chance to avoid his debilitating addiction to alcohol and marijuana, having been exposed to both in significant amounts before the age of 10. Dr. Smith also found that Mr. Honie's addiction to all of these substances resulted directly from both genetic and environmental factors. Dr. Smith noted that the literature indicates that children of parents who abuse alcohol or other drugs are 5 to 7 times more likely to develop an addiction. With regard to his parents, as we know, both his parents were alcoholics. In addition, his maternal and paternal aunts and uncles have significant histories of substance abuse. Consequently, Mr. Honie was genetically predisposed to develop his own addiction. The research regarding alcohol and drug dependence indicates that children who grow up in dysfunctional family environments are at an increased risk for substance abuse. These individuals also develop psychiatric symptoms and/or disorders, and they learn to self-medicate with alcohol and other drugs. Dr. Smith also explains how Mr. Honie's psychological disorders and extreme intoxication on the day of the crime impacted his actions at the time of the crimes. Given the report of drugs and alcohol Mr. Honie consumed on the day of the crime, he was acutely intoxicated by the effects of alcohol and drugs that he consumed during the time leading up to the offense. Dr. Smith states, all of these substances impaired the functioning of his central nervous system at the time of the instant offense, and the PCP, methamphetamine, and marijuana were active during the time of his arrest and interview by the police. Each of these substances caused Honie to experience mood swings, poor impulse control, difficulty with attention and concentration, disrupted processing of information. It gave him poor judgment, aggressive behavior, and distorted perception. Dr. Smith then explains that the interaction between Mr. Honie's substance abuse and his untreated psychiatric disorders interacted and had a synergistic effect. Each disorder exacerbated the negative effects of the other, causing him to be desperate, impulsive, emotionally labile, and erratic at the time of the crimes. In Dr. Meyer's report, he found that Mr. Honie had an extensive and well-documented substance abuse history. Again, discussing the history that we've discussed, he found that he had a history that is also significant for multiple head injuries, including significant loss of consciousness from injuries and intoxication. With regard to his head injuries, Dr. Reynolds yesterday touched on this briefly. Dr. Meyer notes that Mr. Honie reported as a child to be engaged in rock fights with others. He had a pastime called ram power with his older brother, where they would stand at a distance and run at each other and hit each other's in the head to see who would pass out first. He also, he and other children would put themselves in aluminum tubes and roll down the mesa. He also had a significant head injury when he fell from the mesa. He was at Walpi Village, which is one part of the mesa, when he fell and hit his head on a rock, which knocked him out and then caused him to tumble down the side of the mesa landing many feet below. He was airlifted by helicopter to a hospital in Flagstaff. He was unconscious for 45 minutes to 60 minutes before coming to the hospital. Dr. Meyer stated that given the description of this fall, it is possible Mr. Honie hit the area of his head associated with the right parietal and occipital regions of the brain. Dr. Meyer opines that these and other head injuries, along with his probable prenatal exposure to alcohol, extensive history of alcohol and substance abuse, and the acute toxic effects of substantial alcohol and marijuana was found in his system after the crimes had an effect on his behavior at the an effect on his behavior at the time of the crimes. He concludes that some of the grisliness of this crime is tied to the fact that Mr. Honie had a compromised brain that resulted in executive function deficits and was further complicated that night by the acute effects of substances that impaired his executive functions. Throughout the state's presentation, they asserted that we are trying to overturn Mr. Honie's conviction and sentence by asking this board to commute a sentence. This misunderstands the board's role today, which is to decide if Mr. Honie is worthy of the board's mercy and grace. We are not here today to attempt to change the balance of the aggravation and the mitigation at the time of the crime, at the time of the trial and sentencing. We are not here questioning the state and federal court's decisions with respect to our ineffective assistance of counsel claims. The board has been clear through its statutes, rules, and instructions to both parties that this is not a court proceeding. Mr. Boyer is also incorrect that we have not presented any evidence that wasn't already presented at trial and sentencing. While Dr. Cohn scratched the surface of Mr. Honie's background, she did not explain to the court how Mr. Honie's traumatic background and substance abuse had an effect on the crime. Mr. Boyer also stated that there's no evidence that Mr. Honie has brain damage, arguing that Dr. Cohn was an experienced neuropsychologist. Dr. Cohn is not a neuropsychologist. She's a psychologist, and she only performed neuropsych screening, which is not the same as a full neuropsych workup as was done with Dr. Meyer, whose findings I just discussed. The evidence we have presented to the board was developed during our work during federal habeas proceedings. The declarations we obtained from the family members details their traumatic histories and those of Mr. Honie's, details the traumatic histories of Mr. Honie's mother and father and siblings. And the experts we retained during federal habeas for this hearing present new information that was never considered by any state or federal court, Dr. Gilbert and Dr. Reynolds. The state has said that for someone to be deserving of commutation, they have to have an immaculate record and demonstrate acts of charity and helpfulness to others while they're in prison. They have to go above and beyond. Mr. Honie has limited ways to help others because he is in prison, but he has helped in the ways that he can. He has worked when he had the opportunity, including as a plumber most recently, which I will discuss shortly. He also held other jobs at the prison when death row prisoners were allowed to have this opportunity. He is also supportive and helpful to other prisoners. He has also had an important role as a parent and grandparent to Tressa and Alana, even within the confines of the prison. Mr. Boyer believes Mr. Honie is not worthy of commutation because of the two recent disciplinary incidents. Mr. Honie's prison record over 25 years shows that he is not a risk of violence and that the prison agrees because they just restored his level 3 status. It is important to recognize the timing of these incidents, which occurred after his case was at an end and he knew that a warrant of execution would be coming. Mr. Boyer argues that Mr. Honie chose to be drunk and high that day. However, Mr. Honie didn't make a choice to be addicted to alcohol. It is a disease that he was exposed to as a small child and developed himself while still a child. Mr. Boyer also blames Mr. Honie for returning to Palaca, where he was exposed to alcohol and drugs within his community after living with his aunt Del Rita, where he experienced positive influences and did well in school. However, Mr. Honie was just a high schooler at that time. When he returned to live with his family, he cannot be faulted for wanting to be with his family. Mr. Boyer said that it isn't true that Mr. Honie just slapped the other prisoner during the recent altercation. He states that this is a misrepresentation by Mr. Honie. He reasons that a slap could not have caused a laceration to the chin. However, the laceration occurred when the prisoner fell to the floor. Mr. Honie wasn't lying when he said that he had slapped the other prisoner. Mr. Honie's been incarcerated on Utah's death row for 25 years, during which he has demonstrated that he is not a risk of danger to others and can live productively and positively. During the course of his 25 years on death row, there were only 8 disciplinary infractions for things such as refusing to rack in, disobeying an order, and possessing contraband. Mr. Honie discussed these incidents with the board and has been honest with the board about them. There is the solitary BO2 charge related to the incident I just mentioned for striking another prisoner once after the prisoner got in his face and threatened to hit him. While the prisoner continued to pursue Mr. Honie walked away. Mr. Honie has also honestly discussed this charge with the board yesterday. It is an anomaly in what is otherwise a record free from violent incidents. Mr. Honie's record reveals many positive reviews of his attitude and work, demonstrating excellent adjustment to prison. Mr. Honie has also held jobs at the prison and has always taken pride in his work and done his jobs well. Mr. Honie has demonstrated he can exist in prison. As this board knows, from the recent institutional progress report, Mr. Honie did well in general population, received good to excellent work ratings, has had no issues in the Antelope facility, and was recently returned to the security level 3. His most recent work experience was as an institutional plumber, which is a position of significant trust at the prison. Mr. Honie's plumbing supervisor provided a declaration, which we included in our materials to the board. Mr. Sager states that Mr. Honie is the only death row prisoner who has ever been hired to work as a plumber. Mr. Sagers found Mr. Honie to be a good worker who took direction well and who had a positive attitude. He also found Mr. Honie to be respectful and pleasant to work with. Mr. Honie even helped to train other prison workers. As part of his plumbing work, Mr. Honie was entrusted with and responsible for a bucket of tools, which included screwdrivers, a hammer, pliers, and a razor knife. Mr. Sager stated that he always felt safe around Mr. Honie. He stated that Mr. Honie was good about watching over his tools and about watching each other's backs. Mr. Honie wanted to fix things and to help people, and he took pride in his work. Mr. Honie's disciplinary records reflect that he can be safely housed at the Utah State Correctional Facility. Despite his recent disciplinary infraction last year, the prison restored his level 3 classification. This means the prison has found that he is not a risk, can live in general population, can work again, and be able to move freely, among others. Even those who commit terrible crimes are worthy of mercy and grace. If they are truly remorseful for their acts, accept responsibility, and accept punishment. Mr. Honie has always expressed genuine remorse and sadness for his crimes against Ms. Ben and her grandchildren. At his sentencing hearing, he apologized to Ms. Ben's family, saying that he was deeply sorry for killing Dee and for taking her out of their lives. He told them that he had no excuses for his actions. He said, "I'm sure you want me dead. Maybe you'll get your wish. Whatever I get, I deserve. Whatever it is will not be as bad as what I have to carry with me until the day I die. I'll pay for what I've done in this world and the next. I want to pay for what I did. I sentenced my daughter and her cousins to grow up with the horrible memories I put in their minds. If they have to deal with it, so do I. I just hope that as they are growing up, they will be able to forget these memories. I hope and pray they do." These are words of contrition. Yesterday, he came before you and expressed his continued remorse for the crimes he committed and accepted responsibility for his crimes. He said, "I did that. I'm responsible." He also apologized to Ms. Ben's family, who is also the family of his daughter and granddaughter. And he apologized to Dakota, Tony, and Tressa for what he did and for taking their grandmother from them. Mr. Honie continues to be deeply remorseful for his actions and the lasting impact they have had on his daughter and the family and community of Ms. Ben. Mr. Honie has always taken responsibility for his crimes. While he doesn't remember everything because of the extreme intoxication he was under at the time of the crime, he was the one who was there, and he accepts responsibility for everything that happened when he was there. Mr. Honie does not remember the crime committed against Ms. Ben's granddaughter, but he does not deny it. While he doesn't remember everything because of his extreme intoxication, he was the one who was there and accepts responsibility. Mr. Honie has spent 25 years on death row. He is not asking you to be let out of prison, nor does he think he deserves it. Mr. Honie is asking you to allow him to live so that he can continue to be a part of the lives of his daughter, Tressa, and his granddaughter, Alana. He is asking you to allow him to live so that they and the rest of his family do not suffer more than they already have. We are asking you to act as the jury Mr. Honie never had, and to show Mr. Honie mercy based upon who he is today, not who he was 25 years ago, and grant him the ability to continue his existence in prison. Thank you.
Does the board have questions? Ms. Sturba?
Thank you for your remarks. So Mr. Honey was sentenced over 20 years ago, and as the state brought up, multiple courts have reviewed the conviction and the sentence, and in each instance has helped upheld both. Um, can you kind of answer for us kind of your perceptions about whether it's an inappropriate um, exercise of the board's authority to commute the sentence at this point? And would that be an inappropriate substitution of judgment for the courts that have already reviewed this?
I don't think that. I think that clemency is something that's unique and outside of the court process. It's been around forever, and it's something that the executive has the authority, and in this case, the executive in the state of Utah is given the power to this board to do that. We're not, Mr. Honey isn't here to rethink his conviction or sentence. I mean, when you are looking at commuting someone's death sentence as we are today, you are looking at different things. You are looking for who he is now, what has happened to him over the course of the last 25 years. We're not revisiting the time of trial or sentencing. And I hope we've demonstrated to you that he's grown as a person. He's become a much better person. He admits that he was selfish at the time of the crime. He was 22 at the time of the crime, and he had experienced a lot of different kinds of traumas that had a huge impact on him. But after being in prison for a few years, he decided that that wasn't who he wanted to be, and he has worked very hard over the course of the last 2 decades to become a different person, and he has demonstrated that. Clemency is, like I said, it's outside of the court system. It's a matter of mercy and grace. It's a matter of someone coming forth and honestly expressing remorse and honestly accepting responsibility, but also accepting punishment. He's been on death row for 25 years. Living the rest of his life in prison will be a punishment, but it will also allow him to be there for his daughter and granddaughter and his family.
Thank you for answering my question.
Any other questions from the board? Okay. Well, that concludes our presentation phase and concludes this commutation hearing. I want everybody to know that we'll take all the information that we've been given and also the information that's been provided in this hearing and deliberate. And it's not something that we take lightly. I can't speak for everybody on the board, but for me, with each passing minute, the weight of this decision I started to really feel. And whenever you have an opportunity to look somebody in the eye, it has an emotional impact on you. But I want to thank all of you, petitioners, counsel, state counsel, for your decorum and the professionalism in which you have conducted yourself in this difficult case. I want to thank the supporters and family of Mr. Honey. I'm sure it's very hard for you, and this is very hard for you. I appreciate you having the courage to share your thoughts with us as a board. And then ultimately, Claudia Ben's family, very hard for you. And I know it took a lot of emotion, a lot of courage to come and be a part of this hearing. I want you to know that we take those words very seriously. From this point forward, we will adjourn and deliberate. I don't have a time frame, whether it's going to be this week or next week. But rest assured that we'll take our time and view this evidence very thoroughly. And And we'll post our decision and our vote online and notify everybody that needs to be notified of our decision. This board is adjourned.
And with those final words from the board member, I'd invite you to take a moment to meditate and to think about what Mr. Honie must be experiencing while he awaits to hear his judgment, what the panel is going through as they wait to decide his judgment. At the time of me speaking right now at this moment, it's only 7/26/2024. His execution date is sentenced for August 8th, 2024, and I don't have the results. Now, Richard and I discussed, should we wait to do this hearing until after we have the results? And the decision was made to go through without knowing, because I think that adds to the magnitude of this hearing, not yet knowing the decision. Now, as soon as the decision is made and the different events happen, I'll put those results in the description if you want to go and check it out. But for now, we don't know the results. And we're not going to spend a lot of time unpacking this. I think that we got a descriptive version in this hearing. And if you've seen the full unedited 7-hour version, then you have everything. If you're watching the 2-hour compacted version and you want to see the full unedited version, you can click the link below. I'll just share some of my perspectives. I'll share an article from written in 1999 after the judge sentenced him to death. But in my opinion, from what we saw here, I didn't see any of those boxes that were checked. That, you know, what are the reasons that you can grant clemency? It's not a reason of, well, we're ideologically against the death penalty. It's not a reason of anything being unconstitutional. It comes or that there was decisions that were made that shouldn't have been. It really comes down to the idea that they said, well, he could have been a great inmate, or well, it could have been that he did things that were extraordinary, or maybe there were items that they didn't consider in the initial sentencing. And I don't think they checked any of those boxes, frankly. It's interesting to think that a board that was, you know, that a board can overturn the Supreme Courts of the state and the federal government on their own is quite interesting in itself. But we are in that situation. And I just, you know, for those of you who have watched many commutation hearings like me, we don't often see someone that has a fighting write-up and a write-up for intoxication right before their commutation date. Now, his defense argument was, well, it was the idea that his execution date was closely approaching, and that's what triggered it. But you can just come back with another argument, which is he would have known that there would have been one final Hail Mary appeal, and that having a fighting and an intoxication write-up is not going to help you. It's only going to bring you one step closer to the hangman's noose. Now, in Utah, they actually offer firing squad, which is what the last execution took place. And it seems that he's objecting to the firing squad. He's asking for the chemicals, which could be a tactic, could be a strategy, because there's a lot of controversy around that. It's difficult to get the chemicals. There's a lot going around. We're not going to get into it, but that's happening now. There's a chance of maybe there can be a screw up in the middle of it, and he can survive it. And he can file double jeopardy, which has happened before, although the inmate lost. On a personal note, I think firing squad is the most humane way to go, but that's just my 2 personal thoughts. I thought there was just there was so little, this is his time to fight for his life. This is his time to say why he shouldn't die, and he shows up without a written statement. He shows up just talking from the hip. He shows up and he is caught in lies. He says that, I don't even remember going into the taxi. I didn't have money. How could I have taken a taxi? And a minute later, he explains how he gave the taxi $20 and waited for change. How do you do that on the day that you are pleading for your life? He has all these attorneys and support that would have prepared him for this, and he couldn't take a few moments to put it on paper, what he was going to say. He couldn't just own it and say, yeah, I took a taxi there. He's throughout the hearing denying. There was one word that he must have said 20, 30 times. I should have counted. What was it? If I was in my right state of mind, this would never have happened. And it's like, of course, if you were in your right state of mind, this would have never. I mean, you clearly weren't in your right state of mind. And it's so like belittling, I think, to the fact he never, even now, took responsibility for everything that he did, and he was in denial. He was claiming that he only told the doctor what the doctor reported about the most horrible aspects of his crime because they told him, oh, just say it and you'll get out. Are you kidding me? We know what happened. You know what happened. And on the day of the hearing where you're pleading for your life, you're going to lie again? You know, if someone could watch this hearing, it's like, there's I guess either you believe in the death penalty or you don't. And if you don't, then that's it. You just don't. And someone might argue, well, what's the big deal? He why do you have to kill him? You know, it seems that there's not even from the surviving victims, it's not even that clear. It's not like they're asking for it. Why does the state have to go and see the law through, see the sentence through? And I'll tell you one thing about this from what we have seen happen in Louisiana many times is that we have seen those who are sitting on death row get commuted to life, and from life get paroled. We have seen it more than once, more than twice, more than 3 times. It happens. The news doesn't report it because people forget there's not, but it happens. And when you get commuted to life, you are now one step closer. And as Mr. O'Shea once said about this, he's going to be tempted to have another bite of the apple. Mr. O'Shea is a retired board member, a wise man from Louisiana. And he will be. And to think that he won't, you'd have to be naive, because 10 years will pass, 20 years will pass, a certain time frame will pass, and he will file to have his sentence commuted. Oh, he's older now. He served enough time, 50 years. All he did was take one life. We see people getting those. I don't think you need to have a magic globe to predict that can happen. Then there's the other discussions about others, with the death penalty. If other folks can say, yeah, I see people keep getting let off, it's not really a death penalty. The You know, the death penalty is a good tool for prosecutors to have. It's a good tool in their toolbox, because if they're sentencing someone, or if it's that person, if they can only face life in prison, the defendant, why won't they go to trial? Why won't they make the victims get up and testify? They have nothing to lose. Well, the prosecutor can say, well, we're going to try you for the death penalty, or we'll give you life in prison. They can often say, you know what, I'll take life in prison. You can save the cost and the trauma of a trial. But if you take away the death penalty, or if someone watching this sees, the death penalty is not real, that's another argument. I'm very out of the weather, if you haven't been able to tell. And, I wish I could do it. These are the kind of recordings, I wish I could change it and do it and redo it. Let's just go look at what the judge said. Killer sentenced to die. Judge says he earned it. And you'll see how he earned it. This is published May 22nd, 1999 by the Associated Press. Taberon Dave Honie had been sentenced to die for killing and sexually assaulting his girlfriend's mother. The sentence was handed down Thursday by the 5th District Judge, Robert Braithwaite, who said, "It was not a sentence I gave to the defendant. He earned it. If this isn't a death penalty case, I don't know what is." The judge then stayed the execution pending the automatic appeal required by the state law. Braithwaite said he welcomed the appeal and a review of the case, but he hopes it is not remanded back to trial. Honie, 23, was convicted of aggravated murder on July 9th, slaying of Claudia Ben, 49, at her home. Ben was at her home with her 3 granddaughters when Honie used a rock to smash through a glass patio door. Honie cut Ben's throat 4 times from ear to ear and slashed her repeatedly with the kitchen knife. After the sentence was announced, Honie mouthed the words, "You got it," toward Ben's 30 or so friends and family members sitting behind the prosecutor's table. A member of the Honie Ben's family cried. And remember how his defense attorney made it seem like he was taking accountability. Meanwhile, here he's actually looking at them, trying to flip it around, trying to make them the bad guys and he is the victim, actually mouthing to their family, "You got it." Iron County Attorney Scott Burns told the Honie family he was sorry as he left the courtroom. One of Honie's aunts responded, "I hope you enjoy your fun." And she said to Ben's relatives she hoped they could live with their conscience. No one of the Ben family responded. Again, the family of the victims being victimized, even at trial. Earlier, Ben's oldest daughter, Carol, Honie's ex-girlfriend and mother of his 2-year-old daughter, testified she would have been satisfied if Honie were sentenced to life in prison without parole. In making a plea for the judge to spare Honie's life, defense attorney Steve McCaughey asked him to consider what a father means to a daughter. There's the irony in that. McCarty said, "It doesn't seem to fit for the state to execute the father of a girl who lost her maternal grandmother. The girl is entitled to have a father to visit with." Burns argued the death penalty was the appropriate punishment and rejected claims that mitigated factors such as poverty, substance abuse contributed to the crime. Burns stressed the importance of Ben's role as a substance abuse counselor for the tribe under Cedar City. And again, that the irony of that and the idea of that, it shouldn't be, when you have these cases, people can go on monologues and tangents of how special a person was that died. And you see that in true crime. And it kind of irks me in a way, because in many cases, it's just not true. You don't need to go on a 90-second monologue on how, and they always say this, she would take her shirt off her back for someone. It's like, do you realize how pathetically cliche that is? Like, I get, it's really tragic that someone's killed, but you don't need to make a monologue about how they were the next Jesus. In this case, she was so unique. She was a substance abuse counselor. She was a pillar of the community, and a word to be used that he's a pillar to their family. How often have we seen how inmates are called pillars to their family when they're sitting behind bars? Is also a joke. She was, on the other hand, a pillar to the community. She was a substance abuse counselor. She, against all odds, put herself in the situation to help her community. And everyone brings up all of these other facts without even taking that into consideration, his defense, and it's upsetting to me. Honie did not murder a drunken Indian in the park, and I'm reading this by quote, okay? Burns said, this is a prosecutor, he murdered a superstar in their community. Honie, who is a Hopi, read a written statement in court Thursday that said, please don't think that I don't have any remorse or sympathy if I don't cry or show how I really feel. This is what he's saying. Please don't think that I don't have any remorse or sympathy if I don't cry or show how I really feel. It's just that I was taught by tradition that if you're a male, you don't cry openly. During the past couple of days, there is not one moment that went by that I didn't feel like throwing myself on my knees and begging for forgiveness from everyone I hurt. And that's the hypocrisy. He didn't shed one tear at trial. He didn't shed one tear in appeal. And I guess to his credit, you could say, hey, he didn't shed one tear in his defense to save his life. Maybe it is a cultural thing. Maybe he doesn't have the ability to cry. Maybe it's his ego. I don't know what the reasons are. But I didn't see anything here. I didn't see accountability. I saw lying. I saw blame. I saw someone who's really just has not accepted how horrible of a crime it is that he committed, and that maybe he does have that inner monster in him and he just doesn't want to accept it. We're going to have to see what they decide. I'm happy I'm not in their shoes. On one hand, you're saying, let him just live and die in prison, overturn the rulings of the Supreme Courts because, or follow through with what the courts have decided and see the sentence through. With that, I'll let you go.